Imagine a contract where one party can just terminate the whole agreement without any cause just by saying a single word 3 times in a row.
Right. Just instantly.
Yeah, exactly. And now imagine that this specific contract dictates, the lives, the finances, the living arrangements, and the custody of an entire family.
It's pretty staggering when you frame it like that.
It really is. And for decades in India, I mean, that wasn't just some hypothetical law school exercise. That was the lived reality for millions under the application of instant triple talaq.
Oh, absolutely.
You don't sign a termination paper, you just speak it into existence, and the whole architecture of a family is instantly legally demolished.
And, that instantaneous demolition, it really represents the absolute extreme edge of a legal system that is constantly wrestling with itself.
Wrestling with itself how, exactly?
Well, I mean, you have these classical religious texts, right? Texts built for a 7th century agrarian society, and they're colliding head-on with the constitutional framework of a 21st century secular republic.
Right, a total clash of eras.
Exactly. It is messy, it's fiercely contested, and the stakes are quite literally the survival and dignity of the individuals involved.
Which brings us directly to you, our listener, because you are currently navigating the trenches of Osmania University's Family Law 2 curriculum.
Yeah, and it is a dense curriculum.
Oh, for sure. We have your Unit 2 syllabus right here.
Yeah.
And it covers this sprawling, complex web of Muslim personal law regarding divorce, maintenance, the 1939 and 1986 acts, and those really deep sectarian fault lines.
And our mission today isn't to just read your textbook to you, right?
No.
You already know the basic 101 legal terms.
Exactly. You need to understand the underlying mechanics, the how and the why these laws operate the way they do, and, how they shatter or shield the people bound by them. So let's dive into this deep dive.
Sounds good. So to understand how this system breaks down a marriage, we really first have to understand the specific engineering of how it builds one.
Right, the foundation.
Yeah, because under Muslim law, marriage nikah is not a sacrament. It is fundamentally a civil contract.
Okay, a contract. That's a huge distinction.
It is. And because the foundation is contractual, the validity of that foundation dictates every single legal remedy available upon its dissolution.
And the syllabus actually categorizes this foundation into 3 tiers, right? Valid, void, and irregular.
Correct.
So a valid marriage is obvious. I mean, it meets all the criteria. But let's look at the void, or batil, marriage. If a marriage violates an absolute prohibition like consanguinity, so marrying a close blood relative, it's batil.
Yes, absolutely void.
Legally, it never existed. But wait, if a batil marriage is void ab initio, meaning it's a legal nullity from day one, what happens if that couple has children?
That's where it gets really complicated.
I mean, you can't just erase the biological reality, right? Are those kids just deemed illegitimate overnight with 0 rights?
Well, under strict classical application, yeah. Yes, they are. That is the harsh reality of a void contract.
Wow, really?
Because the law recognizes no marital bond, recognizes no legitimate offspring from that bond.
That is brutal.
It is. The children have no inheritance rights from the father, and the wife has no right to maintenance or dower. The state essentially treats the arrangement as if 2 strangers merely cohabited unlawfully.
That seems incredibly punitive, especially to the children who obviously had no say in the contract. Does the law offer any buffer, or is it just a cliff edge?
Well, the buffer exists in the 3rd tier.
Okay.
And that's the irregular or facid marriage. This is actually a really brilliant piece of legal pragmatism.
Okay, how so?
An irregular marriage isn't fundamentally void. Rather, it suffers from a procedural defect.
Like what kind of defect?
For example, marrying without the required number of witnesses, or a man marrying a 5th wife when the law only permits 4 concurrently.
Ah, okay, so it's a defective contract, but not an illegal one?
Precisely. And the mechanical difference here is that an irregular marriage can be cured.
Oh, I see.
Yeah, if the man divorces one of his 4 wives, the 5th marriage can become valid. Or if witnesses are subsequently brought in, the defect is removed.
And what about the kids in that scenario?
All right, here is the crucial protection for the children. Even before the defect is cured, if an irregular marriage is consummated, the children born of it are considered entirely legitimate.
Oh, that's a huge relief.
It is. The wife is also entitled to her dower. It prevents that absolute disenfranchisement that a batil marriage triggers.
Okay, you brought up dower, or Mar. And I think we need to spend some time here because this seems like the primary financial engine of the marriage contract.
It absolutely is the engine.
And Western media often mistranslates this as dowry, which is factually backwards, right? Dowry is wealth flowing from the bride to the husband's family.
Exactly backwards, yes.
Mar flows in the exact opposite direction. It is a legally enforceable financial obligation paid by the husband to the wife.
It is the sine qua non of the Muslim marriage contract. A nikah simply cannot exist without Mar.
Wait, really? What if they agree to not have one?
Even if the contract explicitly states there shall be no Mar, the law will step in, invalidate that clause, and impose a proper dower based on the woman's social standing.
Wow. So it's mandatory.
Yes, and it is her absolute exclusive property.
Okay, so the syllabus breaks Mar into prompt and deferred. Prompt is payable immediately upon demand. But deferred Mar is where the contractual engineering gets really interesting.
Oh, definitely.
It's payable only upon the dissolution of the marriage, either by death or divorce. If I'm looking at this mechanically, deferred Mar acts as like a financial poison pill built directly into the contract.
That is an excellent way to conceptualize it.
Right. It's a predetermined exit penalty.
Exactly. If a husband wants to unilaterally dissolve the marriage, the law requires him to immediately trigger that financial penalty.
So it forces him to think twice.
Precisely. By setting the deferred Mar high enough during the initial contract negotiations, the bride's family creates a severe economic deterrent against arbitrary divorce.
That makes total sense.
It forces the husband to calculate the exact financial ruin he might face before he even utters the word talaq.
But, I mean, the law still allows him to utter it. Which brings us to the actual mechanics of the exit. If a husband decides the penalty is worth it, how does he execute the dissolution?
Well, the popular perception is just the sudden shout of triple talaq, right?
Yeah, that's what's usually in the news.
But the classical texts actually prioritize what they call the approved methods, talaq al-sunnat.
Okay, and talaq al-sunnat is entirely structured around forced pauses, isn't it? And the preservation of revocability.
It is. It recognizes that human relationships are volatile, that anger creates sudden, destructive impulses.
So they slow it down?
Exactly. The law imposes a temporal architecture to slow the destruction down. And this comes in two forms, asan and hasan.
Let's break down the mechanics of asan, which the syllabus says is considered the most approved form. The husband makes a single pronouncement of divorce.
Just one, yes.
But he can't just do it on a Tuesday morning over coffee, right? The timing is strictly regulated.
Very strictly. He must pronounce it during the wife's tur, which is the period of purity between her menstrual cycles. And crucially, he must not have engaged in sexual intercourse with her during that specific tur.
Why that specific biological window? Like, what does her menstrual cycle have to do with his legal right to terminate the contract?
It serves two distinct functions, actually. Psychologically, it removes the immediate impulsivity.
How so?
Well, if he gets furious during her menstruation, he is legally barred from pronouncing asan talaq. He must wait. And that waiting period often allows the anger to dissipate.
Oh, I see. A literal cooling off period before he even says it.
Exactly. And biologically, the stricture against intercourse ensures that if a divorce is pronounced, there is absolute clarity regarding whether she is pregnant.
Right, to avoid overlapping paternity claims.
Yes. In a system where inheritance and legitimacy are paramount, avoiding those claims is essential.
So he pronounces it once? Then what? Are they just divorced?
No. That single pronouncement triggers the idat period.
The waiting period.
Right, usually spanning 3 menstrual cycles. And during this entire idat, the divorce is entirely revocable.
So if he changes his mind?
If he changes his mind, or if they resume marital relations, the talaq is instantly nullified. The contract remains intact.
Wow.
The divorce only becomes final and irrevocable if the entire idat period expires without any revocation.
It's literally a mandatory cooling off period. Now, the second approved method, hasan talaq, that stretches this out even further, doesn't it?
It does. It requires 3 pronouncements, but they are spread out.
Right, across 3 consecutive tour periods. So he says it once, waits a month, says it twice, waits a month, says it a third time, and only then is it irrevocable.
Exactly. And again, if they resume relations at any point before that third pronouncement, the whole process is aborted.
So the system is really trying to stop the divorce.
The entire structural intent of talaq al-sunnat is reconciliation. It builds in multiple exit ramps from the divorce process itself.
Which makes the historical reality of India's application of Muslim law absolutely baffling.
It really does.
I mean, if the foundational jurisprudence is so obsessed with pausing and waiting and reconciling, how did talaq al-badat, instant triple talaq, become this dominant, terrifying weapon we saw in modern headlines?
Well, talaq al-badat literally translates to innovated divorce. It is a deviation.
Where did it even come from?
Historically, it is traced back to the reign of the second caliph, Umar. He permitted it under very specific exigent circumstances to deal with soldiers hastily marrying and divorcing women in conquered territories.
But the mechanics of it completely subvert the approved methods we just talked about.
Completely. A man says talaq 3 times in one sitting. No chur requirement, no iddat waiting period before it takes effect.
The marriage is just instantly, irrevocably annihilated the second that third word leaves his mouth.
Yes, and the jurisprudential paradox that haunted Indian courts for decades was this. Across the spectrum of Sunni scholars, instant triple talaq was considered sinful.
Sinful?
Yes, it was universally condemned as morally abhorrent and bad in theology. Yet the courts held that it was good in law.
That makes no sense. I mean, if a religious legal system views an action as a sin against its own tenets, how does the secular court enforcing that religious law decide it's legally binding?
It comes down to precedent. For decades, the Indian judiciary operated under a principle of non-interference with established personal laws, relying on colonial-era precedents.
Ah, the British courts.
Right. The British Privy Councils had recorded that while bidat was sinful, it was an established, practiced custom among Hanafis.
So the Indian courts just went along with it.
They were reluctant to rewrite religious doctrine, so they simply accepted that precedent. If the man said it, the contract was broken, regardless of the theological sin involved.
And that paralyzed the system until 2017. Let's look at the legal earthquake here. The Supreme Court Constitution Bench in Shia v. Union of India.
A monumental case.
Shia was subjected to an instant triple talaq, and she didn't just ask for maintenance. She struck at the constitutional root of the practice.
She did. She argued that state recognition of instant triple talaq violated her fundamental rights under the Indian Constitution.
Specifically, Article 14 and 21, right?
Yes, Article 14, the right to equality, and Article 21, the right to life and personal dignity.
But wait, personal laws are generally shielded from fundamental rights challenges, aren't they? I mean, you can't usually sue a religion for not being egalitarian.
That was exactly the defense raised by the All India Muslim Personal Law Board. They argued the court had no jurisdiction to test uncodified personal law against fundamental rights.
But the Supreme Court bypassed that.
They did, in a narrow 3.2 majority. And they didn't strike it down merely because it was unequal. They struck it down because it was manifestly arbitrary.
Manifestly arbitrary. What does that mean in this context?
It means a practice that allows a man to break a marital tie whimsically, capriciously, without any attempt at reconciliation that cannot be considered an essential religious practice protected by the Constitution.
Okay, so the court declares it void. They say, this doesn't work anymore. But, declaring something void in a courtroom doesn't physically stop a man in a village from throwing his wife out of the house after saying 3 words.
No, it doesn't.
The Supreme Court judgment lacked teeth. That required the legislature to step in, giving us the Muslim Women Protection of Rights on Marriage Act 2019.
And this is where the debate in your Osmania curriculum gets incredibly heated.
Oh, I bet.
Because the 2019 Act didn't just codify the Supreme Court ruling, it fundamentally altered the nature of the act. It took a civil breach of contract and criminalized it.
Let's look at the mechanics of the act, then. If a husband pronounces instant triple talaq, it is now a cognizable and non-bailable offense.
Yes, severe consequences.
The police can arrest him without a warrant based on a complaint by the wife or her blood relatives. The penalty is up to 3 years in prison. Plus, he is statutorily bound to provide subsistence allowance to the wife, and she gets custody of the minor children.
Now, on one side of the academic debate, this is viewed as the ultimate triumph for gender justice.
Because it actually punishes the act.
Right. The argument is that mere civil nullity is not a deterrent. If a man believes the religious divorce is valid, he will force his wife onto the street regardless of what the Supreme Court says.
I see. So they need the threat of jail.
Exactly. Supporters argue the threat of a 3-year prison sentence is required to force compliance and protect women from instant destitution.
Okay, but let me push back hard on that because the jurisprudence here feels, well, contradictory.
How so?
The Supreme Court ruled that instant triple talaq is void, meaning if a man says it, nothing happens, the marriage is completely intact.
Legally, yes.
If the marriage still exists, he hasn't actually divorced her. So the 2019 Act is essentially throwing a man in a cage for 3 years for uttering a phrase that the highest court in the land has already deemed legally meaningless.
That is a very sharp observation.
You are criminalizing a failed attempt to breach a civil contract.
And that is precisely the core critique raised by legal scholars. If the talaq is void, he's still her husband.
Right.
By jailing the husband for 3 years, the state is actively destroying any possibility of the reconciliation that the classical law so desperately tries to protect.
Not to mention the financial aspect.
Exactly. Furthermore, if he's in prison, he cannot earn an income, which renders the statutory requirement for him to pay a subsistence allowance mathematically impossible.
That's a huge paradox.
Critics argue the act weaponizes the criminal justice system in a way that ultimately harms the financial security of the very woman it intends to protect.
It's a fascinating structural tension. You have a religious tradition failing, the civil courts stepping in to nullify it, and the state ultimately utilizing the blunt force trauma of the penal code to enforce the nullification.
It's a very complex layer cake of law.
Now, with the 2019 Act dominating the conversation, it creates this illusion that Muslim law only gives the power of dissolution to the husband. But your Unit 2 syllabus actively forces us to pivot here.
Yes, we need to look at the wife's rights.
Right. There are powerful mechanisms where the wife holds the reins. Let's look at Kula.
Kula literally translates as to lay down or to remove. It is a divorce initiated by the wife.
Where does this originate?
The foundational texts locate this right in the story of Jamila, the wife of Thabit ibn Qais. She approached the Prophet and explicitly stated she had no complaints about her husband's character or religion, but simply felt an intense, insurmountable aversion to him.
She just couldn't stand him.
She could not live with him. And the Prophet permitted the divorce on the condition that she return the orchard he had given her as dower.
That is remarkable. It's basically a formalized, no-fault divorce based purely on emotional incompatibility, recognized centuries before Western legal systems adopted the concept.
It is very progressive in that sense.
But structurally, it's not a unilateral decree by the wife, is it? It's more of a negotiated buyout.
Exactly.
Yeah.
Because the husband holds the inherent unilateral right of talaq, Kula operates as a transaction where the wife purchases her release.
So what are the mechanics of that transaction?
There are 3 mechanical elements. First, she makes the offer to dissolve the marriage. Second, she provides consideration, usually returning the prompt mahr she received, or forgiving the deferred mahr she is owed.
And the third?
Third, the husband must accept the offer.
Wait, if the third element is that the husband must accept the offer, then the ultimate power is still entirely in his hands, isn't it?
Well, yes.
What if she desperately wants out? She offers him double the mahr, but he's just vindictive and says, no, I'm keeping you married to me. Is she just trapped in legal limbo?
Under strict traditional Hanafi law, yes, that was a massive vulnerability. If he refused the consideration, the Kula failed.
That's terrifying.
Now, some modern judicial interpretations have started to argue that if the aversion is severe enough, the court can compel the husband to accept the Kula. But historically, it was a mutual agreement initiated by the wife.
What if they both just want out?
If both parties mutually desire the split and nobody's paying consideration, that is called mubarat.
But neither Kula nor Mubarat solve the problem of the vindictive, stubborn husband. Which leads me to the most mind-bending mechanism in the syllabus, and that's tafweed or delegated talaq.
Yes. Tafweed.
How does a man outsource his own divorce?
Because talaq is a legal power inherent to the husband under the contract, Islamic jurisprudence allows him to act as a principal and delegate that power to an agent.
An agent? Like who?
That agent can be a third party, her father, or most commonly the wife herself.
So it's essentially a corporate power of attorney applied to a marriage contract.
Mechanically, yes.
The husband signs a document granting his wife the executive authority to fire him.
That's a fun way to put it. And this delegation can be unconditional, or it can be tied to specific negotiated stipulations at the time of the nikah.
Like what kind of stipulations?
For example, the contract might state, if the husband takes a second wife without the first wife's permission, the first wife is immediately delegated the power to pronounce talaq upon herself.
And if she exercises that power, is it treated as a kula where she loses her mahr or a talaq where she keeps it?
It is treated exactly as if the husband had pronounced it talaq. She retains her full right to the deferred more.
That is huge.
It is. The courts in India have heavily protected this. In cases like Abdul Shukur v. Ayesha Begum, the courts affirmed that as long as the delegation is clear and the triggering condition is not illegal or contrary to public policy, the wife's exercise of delegated talaq is absolute and binding.
That is an incredibly powerful tool for premarital negotiation. But again, it requires the husband to agree to give her that power in the first place.
True.
What if we have a worst-case scenario? The marriage is toxic. She has no delegated power of tafweed. She tries kula, but the husband maliciously refuses to accept her consideration.
Right.
He won't divorce her, and he won't let her go. This is where the state realizes the personal law has fundamentally stalled, and they install a statutory override switch, right? The Dissolution of Muslim Marriages Act, 1939.
The 1939 Act is a watershed moment. Prior to this, courts strictly applied Hanafi law, which provided almost no grounds for a woman to seek a judicial divorce without her husband's consent.
So women were just stuck.
Many were. In fact, women were resorting to apostasy, renouncing Islam, simply because it was the only legal mechanism that automatically dissolved the marriage.
Wow. Just to get out of the marriage.
Exactly. To stop this, the legislature adopted the much more liberal principles of the Maliki school of thought, codifying them into a secular statute. This allows a Muslim woman to bypass her husband entirely and petition a judge for a decree of dissolution.
And the act lays out very specific mechanical grounds. I mean, she can't just say, I'm unhappy. She has to prove a breach.
Yes.
Cruelty is a major one, and the syllabus notes the courts have expanded this beyond just physical violence to include deep mental cruelty. Desertion for 4 years is another.
Yes, or if the husband is imprisoned for a period of 7 years or more, if he has been insane for 2 years or suffers from virulent venereal disease.
Now,
but practically speaking, one of the most frequently utilized grounds is the failure to provide maintenance.
oh, interesting.
If the husband fails to fulfill his fundamental contractual duty to financially maintain his wife for a period of 2 years, she can petition the court to dissolve the marriage.
Now, there is one ground in the 1939 Act that is so specific it gets its own dedicated section in the notes. Kiarul Bulu, the option of puberty.
Ah, yes.
This looks like a highly targeted legal missile aimed at the practice of child marriage.
It is exactly that. Under classical law, a legal guardian, usually a father or grandfather, has the authority to contract a marriage on behalf of a minor.
Obviously, a minor lacks the legal capacity to consent to a contract.
Right, so the contract is formed without the actual subject's permission.
That sounds like a recipe for disaster later on.
Therefore, the law provides a retroactive veto. The option of puberty dictates that once the minor attains puberty, which the 1939 Act standardizes at age 15 for this purpose, she gains the absolute right to unilaterally repudiate the marriage arranged by her guardian.
So she turns 15 and just says, I cancel the contract. Are there limits on this? Like, can she wait until she's 30 to decide?
No, the legal window is incredibly tight. She must exercise this right before she turns 18.
Oh, a 3-year window.
Yes. If she remains silent after turning 18, the law presumes she has ratified the contract, and there's one massive overriding condition.
What's that?
The marriage must not have been consummated. If consummation occurs after she attains puberty, her right to repudiate the marriage is instantly, permanently extinguished.
Wow. So it's a rapidly closing window of autonomy. But the 1939 Act ensures that if she jumps through that window, the court will sever the tie regardless of what the husband or the guardian wants.
Correct.
Okay, so the hammer falls, the marriage is over. Whether it was the husband's talaq, the wife's kula, her tafweed, or a judge's decree under the 1939 Act, the legal bond is severed.
It is.
But as anyone who has studied contract law knows, terminating an agreement doesn't mean everyone just walks away clean. There is a massive, complex unspooling of obligations. Let's look at the legal consequences of divorce.
The dissolution triggers an immediate chain reaction of 5 distinct legal consequences.
Okay, what are they?
The observance of idat, the shifting of maintenance rights, the immediate crystallization of deferred dower, the battle for custody, and the severing of inheritance rights.
We mentioned idat earlier as a waiting period for reconciliation in asan talaq. But when a divorce is final, idat takes on a completely different, highly rigid function, doesn't it?
It does.
It becomes what looks like a biological audit.
That's a good term for it. The primary jurisprudential purpose of idat is the ascertainment of pregnancy. It is an evidentiary tool designed to prevent the commingling of bloodlines.
Okay, so how does it work in practice?
If a marriage ends, the woman is legally barred from remarrying for the duration of the idat. This is typically 3 menstrual cycles, or if she is pregnant, until the delivery of the child.
Because if she remarried immediately and had a child 9 months later, there would be an insurmountable legal crisis over which husband is the legitimate father,
Exactly.
which dictates who inherits the property.
Exactly. And your syllabus heavily emphasizes the rules of legitimacy tied to this. Muslim law dictates that a child born within 280 days of the dissolution of a marriage is presumed to be the legitimate child of the ex-husband.
Oh, 280 days.
Yes, the iddat period provides the temporal buffer to make that 280-day presumption functionally verifiable.
But wait, I mean, we live in the era of like $99 DNA tests. You can establish paternity with absolute scientific certainty in 48 hours.
You can.
Doesn't that render a mandatory 3-month biological audit entirely obsolete? Why does the law still enforce it?
From a purely evidentiary standpoint of establishing paternity, you are correct. Modern science supersedes it. However, in personal law, iddat has transcended its purely biological function.
How so?
It is deeply ingrained as a period of social transition, a period of modesty, and a structural pause that formally demarcates the end of the union. Courts continue to enforce it not just as a paternity test, but as an essential religious and procedural rite of passage out of the marriage contract.
Right, it's about the social fabric, not just the biology. And as she exits the contract, we hit the consequence of custody. Now, your notes draw a very sharp, very deliberate line between two distinct concepts, hizanat and wilayat.
Very different concepts.
To a layperson, custody is custody, you have the kid. But legally, this is a massive structural division of parental power. Walk me through it.
Hizanat translates to physical custody. It is the right to the day-to-day care, nurturing, and upbringing of the child.
Okay, who gets that?
Under Muslim law, the absolute right of hizanat belongs to the mother. The law presumes that the mother is uniquely equipped for the physical and emotional rearing of young children.
Makes sense.
She generally retains this right until a boy reaches the age of 7 and a girl reaches puberty.
Okay, so the mother is raising the children in her home. What is wilayat then?
Wilayat is legal guardianship. It is the ultimate legal authority over the minor's person and, crucially, their property.
And who holds that?
The natural absolute guardian under classical Muslim law is the father.
Wait, so the mother is waking up at 3 a.m. with the sick child, taking them to school, feeding them, physically raising them. But the father, who might live in another city, holds the legal purse strings and the decision-making power over the child's assets.
Yes, that is the exact friction point. If a minor child inherits property, the mother who has hizanat has absolutely no legal right to sell, lease, or manage that property.
That is wild.
The father, as the wilayat, is the sole legal manager. If the father dies, that guardianship doesn't default to the mother. It historically passes to the paternal grandfather.
That seems like a recipe for disaster. What if the father is a degenerate gambler? What if he's squandering the child's assets while the mother is struggling to buy groceries? Does she have any recourse?
Under strict classical law, her options were incredibly limited. However, this is another area where modern secular law has heavily intervened.
Oh, good. How?
Under the Guardians and Wards Act, a secular Indian court can override these classical strictures. The court's paramount consideration is the welfare of the minor.
Okay, so they can step in.
If the father is deemed unfit, the court can strip him of his wilayat and appoint the mother or a third party as the legal guardian to protect the child's assets.
Okay, so the kids are sorted, the property is locked down. But we have saved the most explosive, politically charged consequence of divorce for last. Section 7 of your unit, the battle for maintenance.
Ah, yes, the big one.
How long does a husband have to financially support the woman he just divorced?
Under classical Muslim law, the answer is incredibly brief and mathematically absolute. He must maintain her during the iddat period.
Just the 3 months.
Once the 3 months of iddat expire, his financial obligation is entirely extinguished. The marital tie is cut cleanly. She is a stranger to him.
Which sets the stage for a legal collision that fundamentally altered Indian politics. Let's talk about the catalyst for that. The 1985 Supreme Court case of Mohd Ahmed Khan v. Shah Bano Begum.
Shah Bano was a 73-year-old Muslim woman. Her husband, an affluent advocate, divorced her after 40 years of marriage.
40 years, wow. He paid her the deferred mahr, he paid her maintenance for the 3 months of iddat, and then he legally washed his hands of her. She was 73, with no income, facing absolute destitution.
So she goes to the magistrate.
Mm-hmm.
But she doesn't file under Muslim personal law because under personal law she has no case. He followed the rules.
Right.
She filed under Section 125 of the Criminal Procedure Code. Explain the mechanics of Section 125.
Section 125 of the CRPC is a secular socialist piece of legislation designed entirely to prevent vagrancy.
Prevent vagrancy, okay.
It states that if any person having sufficient means neglects or refuses to maintain their wife, and crucially, the statute defines wife, to include a divorced wife who has not remarried a magistrate, can order him to pay a monthly allowance.
So you have a direct, insurmountable conflict of laws. Muslim personal law says the obligation ends at 90 days. The secular criminal procedure code says the obligation continues indefinitely until she dies or remarries.
Yes.
What did the Supreme Court do? The Supreme Court, in a unanimous Constitution bench decision, ruled in favor of Shia Bano. They held that Section 125 overrides personal law.
Oh, wow.
The logic was that a secular statute enacted to protect citizens from starvation and vagrancy cannot be circumvented by invoking religious law. If a divorced Muslim woman is unable to maintain herself post-iddat, her ex-husband must pay her monthly maintenance under the CRPC.
I can imagine the orthodox reaction to a secular court telling them their interpretation of Islamic law is invalid.
It was explosive. It was perceived as a direct existential assault on the autonomy of Muslim personal law in India. The political pressure on the government of the day was immense.
Because they felt the court overstepped.
They argued the Supreme Court was effectively rewriting the Quranic boundaries of marriage and divorce.
And so the government yields to the pressure and executes a massive legislative pivot. They passed the Muslim Women Protection of Rights on Divorce Act, 1986.
They did.
And, the title makes it sound like a shield for women, but the actual mechanics of the act were designed to bypass the Shia Bano judgment entirely, weren't they?
Exactly. The 1986 Act is a masterclass in complex statutory engineering. The core provision mandates that a divorced woman is entitled to a reasonable and fair provision and maintenance to be made and paid to her by her former husband within the iddat period.
Within the iddat period. Those 4 words are the entire trick.
Yes, they are.
So instead of paying her like 5,000 rupees a month for the rest of her life under Section 125, the 1986 Act says he has to give her a final settlement, but the entire transaction must be completed before the iddat clock runs out.
Yes. The Supreme Court later clarified this in the landmark Daniel Latifi case. They interpreted reasonable and fair provision to mean that the husband must mathematically calculate her future needs and pay her a lump sum that secures her future.
Okay.
But he must physically hand over that lump sum before iddat ends. Once iddat is over, he cannot be pursued for another rupee.
Okay, but let's look at reality here. What if the husband is a daily wage laborer? He doesn't have a lump sum to give her that will last the next 20 years.
Very true.
He pays what he can during iddat, and then he's legally free. 5 years later, she runs out of money and is facing destitution again. Under the 1986 Act, she cannot sue her ex-husband. So who is legally obligated to stop her from starving?
This is the most fascinating structural element of the 1986 Act. It radically shifts the social safety net away from the ex-husband and onto the bloodline.
The bloodline.
Yes. The Act stipulates a strict hierarchy of liability. If she is destitute post-iddat, the legal obligation to maintain her falls upon her own relatives, specifically the relatives who would be entitled to inherit her property upon her death in proportion to the share they would inherit.
That is brilliant and terrifying at the same time. The law says if you stand to gain from her death, you are legally bound to pay for her life.
Exactly. It ties maintenance directly to inheritance rights.
But what if her relatives are also living in poverty and literally cannot pay?
Then the Act activates the final failsafe. If the relatives cannot maintain her, the magistrate directs the State Waqf Board, the institution that manages Islamic charitable endowments, to pay her maintenance.
So the 1986 Act essentially says that once a marriage is over, the ex-husband is entirely removed from the equation. The responsibility for a destitute woman reverts first to her biological family, and if they fail, to the broader religious community via the Waqf.
Mechanically, yes.
It completely rejects the Western secular concept of ongoing alimony, relying instead on Islamic principles of consanguinity and communal charity to satisfy the state's requirement to prevent vagrancy.
Whether Waqf boards actually have the liquid assets to pay these maintenance claims is a heavily litigated administrative nightmare. But the jurisprudential architecture of the Act successfully severed the ongoing tie to the ex-husband while attempting to preserve a safety net.
Now, as we enter the final section of your syllabus, we have to pull the rug out from under everything we've just discussed.
We do, yeah.
For the last 50 minutes or so, we've been using the term Muslim law as if it's a single, monolithic code. Your notes make it brutally clear that it is not. The entire legal landscape fractures violently based on sectarian lines. We have to dive into the deep divisions between Sunni and Shia jurisprudence.
It is impossible to practice or understand Islamic family law in India without immediately asking which school of law applies to these specific parties.
Because it changes the outcome.
Radically. The differences are not merely semantic, they alter the fundamental outcomes of divorce, marriage, and inheritance.
The fracture starts at the very sources of the law. Your notes outline that Sunni law relies on the Quran, the Hadith, Ijma, and Qiyas. Let's break those down.
The Quran and Hadith, the traditions of the Prophet, are the primary sources for both. But where they are silent, Sunni law turns to Ijma, which is the consensus of the jurists. If the scholars agree on a ruling, it becomes binding.
And Qiyas.
If there's no consensus, they use Qiyas, which is analogical deduction.
Explain the mechanics of Qiyas. How do you deduce a law?
Qiyas involves finding a ruling in the Quran, identifying the underlying cause or reason for that ruling, the illah, and then applying that same ruling to a new, modern situation that shares the identical cause.
Give me an example.
For example, the Quran forbids wine because it causes intoxication. Through Qiyas, Sunni jurists deduce that all modern narcotics are forbidden because they share the same underlying cause, which is intoxication.
Okay, so it's a heavily structured, precedent-based system. Now, how does the Shia school, specifically the Jafari or Twelver school, which is predominant in India, approach this differently?
Shia jurisprudence accepts the Quran and Hadith, but fundamentally rejects Qiyas, the analogical deduction, and the Sunni version of Ijma, the consensus of scholars.
What do they use instead?
Instead, they place supreme infallible authority in the rulings of the Imams, the direct descendants of the Prophet. Where the texts are silent, Shia law relies heavily on aql, which translates to human reason and intellect, guided by the principles laid down by the Imams.
So, Sunni law uses rigid structural analogies, while Shia law relies on authoritative lineage and human reason. How does that philosophical split affect the actual laws of divorce? Because we spent a lot of time on instant triple talaq, talaq al-bidat.
This is the most glaring operational difference in the entire syllabus. As we discussed, in Sunni, specifically Hanafi law, until the Supreme Court intervened in 2017, instant triple talaq in one sitting was legally valid.
Right, it immediately terminated the marriage.
Yes. In Shia law, however, talaq al-bidat has never been recognized as valid.
Never.
Never. Jafari jurisprudence mandates extreme strictness in the procedure of divorce. A talaq must be pronounced strictly according to the approved phased methods.
Ah, the Sunnat methods.
Furthermore, Shia law requires the absolute presence of two competent witnesses when the talaq is pronounced. Sunni law does not require witnesses for a divorce.
So if a Shia man yelled, talaq, 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 at his wife in an empty room, what happened?
Nothing. The marriage remained 100% intact. The pronouncement was a complete legal nullity.
That is staggering.
A Shia woman historically possessed structural protections against arbitrary, instantaneous divorce that Sunni women had to fight all the way to the Supreme Court in 2017 to achieve.
It completely shatters the idea of a uniform personal law. And the divergence isn't just in divorce, it extends to the very definition of marriage. The syllabus highlights a Shia concept called muta.
Muta is a temporary marriage. It is a legally binding contract of marriage, but it is formed for a fixed, strictly specified period of time.
Fixed? Like how long?
It could be contracted for a day, a month, or 10 years.
What happens when the timer runs out? Do they need a divorce?
No, the exact moment the specified term expires, the marriage automatically dissolves. There is no talaq, no khula required. The contract simply completes its term.
And what about her rights during that time?
Crucially, while a muta wife is entitled to her agreed-upon dower, she generally has no right to maintenance under classical law, and neither spouse inherits from the other if one dies during the term.
And how does Sunni law view this temporary contract?
Sunni jurisprudence unequivocally rejects muta. In Sunni law, a nikah must be intended to be permanent at the moment of its inception.
So if you try to make it temporary...
If you include a clause in a Sunni marriage contract limiting its duration to 1 year, the condition is void, and in most interpretations, the entire marriage contract is void.
So a valid contract in one sect is a void legal nullity in another. Wow. Finally, we have to touch on the mechanics of inheritance, because your notes show a massive philosophical split in how wealth is distributed upon death.
The divergence in inheritance law is profound. Sunni inheritance is deeply tribal in its origins. It heavily favors the agnatic male line.
How does that play out?
It divides heirs into Quranic sharers who get fixed fractions, and residuaries, usually male relatives on the father's side. Once the fixed shares are handed out, whatever's left over is swept up entirely by the male residuaries.
And Shia law?
Shia law rejects the Sunni classification of residuaries entirely. They operate on the doctrine of akrabiyat, or blood proximity.
Proximity over gender.
Exactly. The fundamental rule is that the closer in blood excludes the more remote, regardless of whether they are male or female or related through the father or the mother. A closer female relative will exclude a more distant male relative, which directly contradicts the Sunni system.
Let's look at the mathematical mechanics of this, because the syllabus mentions two specific doctrines, ol and rad. What happens if the fixed fractional shares mandated by the Quran add up to more than 100% of the estate?
A classic problem.
Say the math results in fractions that equal 1512. You can't distribute more property than exists.
Exactly. This is the anomaly of the arithmetic. Let's say a woman dies leaving a husband, 2 daughters, and both parents.
Okay, let's do the math.
Under Sunni law, the husband gets 14, which is 312. The daughters share 23, which is 812. The parents each get 16, which is 212 each, so 412 total. Add those numerators up. 3 plus 8 plus 4 equals 15. You have 15 shares, but only a denominator of 12.
So Sunni law has to shrink everyone's piece of the pie.
Yes. Sunni law uses the doctrine of all, which translates to increase. They artificially increase the denominator from 12 to 15.
So everyone takes a hit.
Yes, the husband now gets 315, the daughters 815, the parents 415. Every single heir takes a proportional mathematical haircut.
And how does Shia law solve the 1512 problem?
Shia law completely rejects the doctrine of all. They argue it is unjust to reduce the shares of those whose portions are strictly fixed by the Quran.
So who takes the loss?
Instead, when the fractions exceed the total estate, Shia law applies the entire reduction exclusively to specific heirs, almost always the daughters or the consanguine sisters. So the husband and parents get their full original fractions, and the daughters absorb the entire loss to balance the equation.
And if the math goes the other way, if there's property left over after the fixed shares are given?
In Sunni law, that leftover surplus is immediately handed to the residuaries, the distant male relatives.
And in Shia law?
In Shia law, because they don't recognize residuaries, they use the doctrine of rad, or return. They take that surplus and mathematically distribute it back out to the surviving Quranic heirs in proportion to their shares. The wealth stays within the immediate proximity of the bloodline.
It's an entirely different philosophy of wealth, gender, and family structure, entirely dependent on whether the deceased followed Hanafi or Jafari jurisprudence.
It truly is a dual system.
We have covered an immense amount of ground today. I mean, we traced the fundamental mechanics of the nikah as a civil contract, with Mahr acting as a financial deterrent.
I did.
We explored the deeply psychological, pause-heavy structure of talaqul sunnat and contrasted it with the catastrophic historical anomaly of instant triple talaq. We saw how Kula and Tafweed provide women with buyout options and delegated executive power.
And we watched the state intervene.
Violently, yeah. First with the 1939 Act offering judicial rescue for trapped women, then the explosion of the Shah Bano case reshaping maintenance through the 1986 Act, and finally the 2019 criminalization of bidat. And we ended by mapping the deep tectonic fault lines between Sunni and Shia interpretations of everything we just discussed.
It is a remarkable, ongoing evolution. You are studying a legal system that is desperately attempting to serve a modern constitutional democracy while remaining anchored to ancient religious texts.
Which leaves us with a final lingering thought for you to dissect as you prepare for your Osmania University exams. We've seen how the 1939 Dissolution Act imported Maliki law to save Hanafi women.
Right.
We've seen the 1986 Act restructure the Waqf Board to satisfy secular criminal procedure codes. We've seen the 2019 Act utilize the state's penal power to enforce a religious nullity.
It begs the ultimate question for any student of jurisprudence.
It's that.
As the secular state continues to heavily codify, regulate, and criminalize specific mechanics of these ancient traditions to align them with constitutional rights, at what point does Muslim personal law cease to be religious jurisprudence and functionally become a secular state family code that merely wears Islamic terminology?
A question that the Supreme Court will undoubtedly be grappling with for decades to come. Thank you for handing us such a dense, fiercely complex syllabus to unpack today. Keep interrogating the structures, keep asking the hard questions, and keep diving deep into your legal studies.